Welcome to Negligence 101. This is Class 1, Week 1, First Class on Negligence. And in this class, this is going to serve as our introduction. Negligence matters. It matters because negligence is the dominant basis of tort law in the United States. Negligence matters because it drives insurance claims. It drives settlement negotiations. It lends itself to be a template for best practices in expert testimony. And it drives civil procedure because there's so many negligence cases that are filed, many are settled, and many still go to trial. Lastly, negligence matters to law students because it is heavily tested on the bar exam if the bar examiners choose to test a tort subject. 9 times out of 10, if the bar examiners choose to test a tort subject, it will be tested as an essay and it will be based upon a negligence hypothetical. That's why this semester, negligence will receive the lion's share of our focus and our attention. What is negligence? Negligence is a structured legal claim. Negligence is focused on conduct as behavior or conduct as action. Negligence is not focused on intent. Negligence is not a moral judgment, nor is it about bad intentions. And lastly, from a legal perspective at least, negligence is not proven by instinct or sympathy. As a legal equation, negligence is simple. Negligence is element 1, that's duty of reasonable care. Element 2, breach of that duty of reasonable care. Element 3, causation, which has 2 independent arms. 1, actual cause, also known as factual cause, also can be known as cause and fact. The second prong of causation is proximate cause, also known as legal cause. The fourth and the last element is damages. This is a conjunctive equation, meaning all 4 elements are required. If any one of the 4 elements is missing, you may have something, but it will not be liability for negligence. Quickly, one more time, because this is worth emphasizing. 4 elements: duty of reasonable care, breach of the duty of reasonable care, causation, which has 2 independent required prongs. So both of them are required. You will have to establish actual cause, also known as factual cause or cause and fact, and you will be required to establish proximate cause, also known as legal cause. The fourth element being damages, all of the elements being required. So again, 4 elements of negligence, put them here. Briefly, because as we get through the semester, as we progress through the semester, we will speak to each of these elements in detail, but just a brief introduction of what each one of these elements covers. The duty of care element looks to analyze whether or not the defendant in question, right, is obligated to extend reasonable care to the plaintiff that is harmed. Breach of duty is exactly what it sounds like. Did the defendant fail to exercise the reasonable care that they owed the plaintiff that was harmed? For causation, actual cause is going to establish whether or not the breach of duty of care, if there was a breach, right, made a difference into the existence of the harm or the cause of the harm. And proximate cause, which is the legal cause, is going to focus on the scope of liability. Was the harm that was caused by the plaintiff within the risk that made the conduct of the defendant negligent? And then we look at damages, and damages must establish a legally cognizable harm. Again, we'll go over each of these in a lot more detail. So don't be concerned if you didn't get word by word of what I said for each one of these. This, again, is our introduction to negligence. The governing rule of law as it comes to negligence. As I've explained to you when we were going through the modules on intentional torts last semester, if you are working in a jurisdiction that has a particular statute, in this case, as it relates to negligence, you are going to follow the statute, hands down. If there is no statute, we are going to rely on the third restatement of torts. That's a little different this semester. This semester, we are going to rely on the third restatement of torts. As it relates to negligence, the third restatement of torts has been adopted, has been published, is good law in the absence of a statute. So we will be using the third restatement of torts. So let's jump into the third restatement of torts. How does the third restatement of torts define negligence? Simply, if you look at the third restatement, there's going to be different categories. The category that we are going into for this definition is liability for physical and emotional harm. We're going to go into chapter 1 of liability for physical and emotional harm. And then we're going to study section 3. A person acts negligently if the person does not exercise reasonable care under all of the circumstances. Seems pretty simple, right? Seems pretty simple. The primary factors to consider in ascertaining whether the person's conduct lacked reasonable care are the foreseeable likelihood that the person's conduct will result in harm, the foreseeable severity of any harm that may ensue, and the burden of precautions to eliminate or reduce the risk of harm. So again, how is negligence defined in the restatement third of torts? A person acts negligently if the person does not exercise reasonable care under all of the circumstances. What are the factors that are considered when making the determination as to whether or not the person exercised reasonable care under the circumstances? You're going to analyze, one, whether the person's conduct lacks reasonable care for the foreseeable likelihood that the person's conduct will result in harm. 2, the foreseeable severity of any harm that may ensue. And 3, the burden of precautions to eliminate or reduce the risk. In other words, at the most basic level, negligence is about how a person behaves in the world. How did the person behave? How did the person conduct themselves? What type of behavior did the person exhibit? The law is not asking about what the person intended. The law is not asking whether the person is a good person or a bad person. The law is asking whether the person acted with reasonable care under all of the circumstances. Well, again, what are we looking at when we determine reasonable care? Here they are, one more time. 3 practical factors: foreseeability of the likelihood that the person's conduct will result in harm, foreseeability of the severity of the harm, and the burden of precautions that could have reduced or eliminated the harm. So as you're working through hypothetical scenarios, you must understand that no single factor is dispositive. The question is whether the conduct was reasonable under all of the circumstances. Understand, reasonable care is a legal compromise. Reasonable care is a standard of behavior that does not require perfection. But neither does the standard of reasonable care tolerate carelessness. So again, reasonable care is a standard showing a legal compromise, not looking for perfection, but also not tolerating carelessness. Okay. Why are we using the term conduct? You know me, I'm very particular. What is that the best word for whatever it is you're trying to communicate? Why does so much of the negligence analysis revolve around the word conduct? Especially when you note that the Restatement Third of Torts, Section 3, which defines negligence, does not use the word conduct. Well, the simple answer is this: negligence law evaluates conduct. So when we talk about negligence, we are speaking about conduct in 2 forms. We're speaking about conduct in either an affirmative action or a failure to act when action is required. We are speaking about conduct in 2 forms: an affirmative action or an omission. Negligence is about behavior measured against a known standard. Makes a lot of sense, right? Okay. Let's keep moving through the Restatement Third of Torts. Restatement Third of Torts, liability for physical and emotional harm. Now, Chapter 2, Section 6 explains what liability for negligence is. Section 3 defined negligence. Section 6 defines liability for negligence. Section 6 says an actor whose negligence is a factual cause of physical harm is subject to liability for any such harm within the scope of liability, comma, not period, but comma, unless the court determines that the ordinary duty of reasonable care is inapplicable. So what does that say without saying it? It says that the duty is a determination for the court. Element 1, duty is determined by the court. It is an legal decision, not a factual decision. If it were a factual decision, who decides it? The juries. Okay, so Section 3 gives us the definition. Section 6 helps us understand how a person becomes liable, right? So what's the first question in a negligence analysis? Threshold question, element one. Element one. Does the law require this defendant to act with reasonable care toward this plaintiff? Does the law require this defendant to act with reasonable care toward this plaintiff? Remember, these aren't moral inquiries. These are not character judgment decisions. Make sure that your brain doesn't go down that path. This is a legal standard that has to be judged by legal guidelines. If there is no duty, for instance, if in your analysis the law does not require this defendant to act with reasonable care toward this particular plaintiff, the plaintiff that was harmed, then there is no duty of care owed. If there is no duty of care owed, there is no liability. Why? Let's go back a few slides. We have a conjunctive rule, all of the elements of which are required. If I cannot establish element one, my inquiry is done. If there is no duty, there is no liability. Hold on to that, pin that, make a note about that, highlight that. We're going to get to the case, the case that makes this duty question that may seem right now, what's the big deal? This is pretty simple and pretty straightforward. Makes the big deal really clear. So just hold on to it, okay? The first element, the first inquiry that must be resolved is whether or not the defendant who's being sued had a duty of care to this plaintiff who suffered the harm and brought the lawsuit. Okay. Now, of course, if you're in a testing situation and the hypothetical says it is established that there was a duty, then step one is done for you. Or let's say you're in a hypothetical situation and the hypothetical says it has been established that there was a duty and that the defendant breached that duty. That means that the question is probably then asking about either actual cause or proximate cause or damages, right? So again, don't forget what you learned first semester. When you're in testing situations, read the call of the question and be responsive to what it is that the question is actually asking. If the question is asking if the defendant is liable for negligence, and it's just a kind of general question, then you're going to start from element one, which is duty. Make sense? Which is our threshold question. Okay, excellent. Take a minute, take a break. You want to think about it? Everybody good? Great, let's keep going. Restatement, third of torts, liability for physical and emotional harm. We are now in chapter 3, section 7. Section 7 explains to us what element 1 requires. So because we start with the element of duty, because if there is no duty, there's no need to continue the inquiry. We need to understand what duty requires. Well, section 7 tells us what duty requires. An actor ordinarily has a duty to exercise reasonable care when the actor's conduct creates a risk of physical harm. In exceptional cases, when an articulated countervailing principle or policy warrants denying or limiting liability in a particular class of cases, a court may decide that the defendant has no duty or that the ordinary duty of reasonable care requires modification. Well, that's consistent with what we've said before. What we said before was that the court is making the legal determination about whether or not a duty exists. And so an actor ordinarily has a duty to exercise reasonable care when the actor's conduct creates a risk of physical harm. In exceptional cases where there is an articulated countervailing principle or policy, right, as it relates to a particular class of case, a court may decide that the defendant has no duty or that the ordinary duty of reasonable care may require modification. It's okay. You don't have to understand all of this right now. Don't jump into that rabbit hole, as beautiful as it looks. We're going to get there. Let's get through this overall introduction. So back to duty. When you look at this duty rule that is provided for us in Chapter 3, Section 7 of the Restatement Third of Torts, it makes sense, right? An actor ordinarily has a duty of care to exercise reasonable care when the actor's conduct creates a risk. Well, that's commonsensical. When a person's conduct creates a risk of harm to others, the person ordinarily owes a duty to exercise reasonable care, right? If you create risk through your conduct, the law is going to expect you to act reasonably with respect to the risk of harm that creates for others. Make sense? Makes sense. Let's keep moving. We're doing great. Well, that begs the question. An actor ordinarily has a duty to exercise reasonable care when the actor's conduct creates a risk of physical harm, unless, right, given a particular class of case, a court may decide that defendants have no duty of care. Why doesn't duty of care exist always? Right? The inquiring mind wants to know. Duty of reasonable care does not always exist just because a harm has occurred. The law deliberately resists the idea that liability should arise from mere presence or mere knowledge or mere failure to act. If duty existed whenever someone could have helped, may have helped, would have helped, right? Negligence law would become an open-ended moral command. And that's not the role for law, is it? Now, we can debate if it should be or if it shouldn't be, but the reality is it's not. So let's then look at no duty requirement, right? So when would I not have a duty? Because I know that I have a duty, according to the restatements, if I create a risk of harm to others by my conduct. So when do I not have a duty? Chapter 7, Section 37 of the Restatement Third of Torts explains an actor whose conduct has not created a risk of physical or emotional harm to another has no duty of care. Well, oh, okay. Right? The other side of the coin. If my conduct creates a risk of harm, I have a duty. If my conduct did not create the risk of harm, I don't have a duty. Both of those situations, a court can decide one way or the other, right? So if my conduct creates a risk of harm, then I have a duty of care to others, right? Unless the court says that I don't. If my conduct has not created a risk of harm, then I do not have a duty of care to others unless a court says so. All of that makes sense, right? The latter, which is an actor whose conduct has not created a risk of physical or emotional harm to another, has no duty of care to the other unless a court determines that the actor does. Those times are identified in Restatement Third of Torts, sections 38 through 44. We'll get to those as well. Okay, so moving on. Why would duty sometimes return, for example, as in sections 38 through 44? Well, sections 38 through 44 explains that duty may return when the defendant's position in relation to the plaintiff changes. So what am I saying? I'm saying if you as the defendant did not engage in conduct that created a risk of harm, what does section 7 say? You don't have a duty. Well, actually, section 37 says you don't have a duty, right? Unless the court says you do. Well, when would the court say that you do? The court says that even if your conduct did not create the risk, you may still have a duty of care depending upon your relationship, depending upon your position as it relates to the plaintiff. And again, a lot of this is going to make sense, right? So, what are you saying? What the law is saying is, even though you did not create the risk of harm, you may still have a duty of care to another if you have a special relationship that is recognized by law with the plaintiff, or if you voluntarily undertake responsibility for the welfare of the plaintiff. Okay, so let's think a little bit more. We can jump into those just a little bit. What's some examples? My inquiring mind wants to know. Well, let's look at 38. An affirmative duty based on a statutory provision. An affirmative duty based on a statutory provision. When a statute requires an actor to act for the protection of another, the court may rely on the statute to decide that an affirmative duty exists and to determine the scope of that affirmative duty. When a statute requires an actor to act for the protection of another, the court may rely on the statute to decide. Can you think of anything? What about stopping at a red light? You having a privilege, not a right, but a privilege to drive because you bear a driver's license. So you have a privilege to drive on the roadways, provided you adhere to the laws of the roadways. One of those laws of the roadways is to stop at a red light. That's a statute that requires you to act for the protection of another. And if you fail to act as the statute requires, See where I'm going? All right, well, let's look at 39. What does 39 say? 39 says that you might have an affirmative duty based on prior conduct creating a risk of physical harm. 39, a duty based on prior conduct creating a risk of harm. Well, what does 39 actually say? When an actor's prior conduct, even though not tortious, creates a continuing risk of physical harm of a type characteristic of the conduct, the actor has a duty to exercise reasonable care to prevent or minimize the harm. Okay, well, let's look at 40. What does 40 say? Duty based on a special relationship with another. Well, what does Restatement 40 actually say? An actor in a special relationship with another owes the other a duty of reasonable care with regard to risk that arise within the scope of the relationship. Now, again, what are we talking about? We are talking about times where you as an actor may be found to have had a duty of care, right, to someone who is injured and turns around and sues you as a plaintiff in a lawsuit, right? Even if you did not create the risk. Well, 40 says that may happen if there is a special relationship between the actor, that's the defendant, and the plaintiff. Well, give me an example. An example would be a common carrier, right? You're on the metro bus, you're on the airplane. Another legally recognized special relationship is an innkeeper with its guest. Another legally recognized relationship is a business or other possessor of land that holds its premises open to the public. So, right, we're going to get into some premise liability. Another example would be what? An employer with its employees. What's another one? Well, this one's easy. How about a school and the students within the school? How about this one? Landlord, tenants, a custodian with those in its custody, right? All of those are deemed to be legally recognized special relationships. So even if you didn't create the harm, you still may have a duty of care. All right, let's move on to 41. Duty to third parties based on special relationships. This is different than 40. 40 is duty based upon a special relationship. 41 is a duty to a third party based upon a special relationship. Well, what does 41 actually say? An actor in a special relationship with another owes a duty of reasonable care to third parties with regard to risk posed by the other that arise within the scope of the relationship. Special relationships giving rise to the duty provided therein. A parent with dependent children. A custodian with those in its custody. An employer with employees when the employment facilitates the employees causing harm to the third parties. A mental health professional with patients. We're still not done, right? We still have 42, 43, 44. What is 42? 42 is duty based on undertaking. An actor who undertakes to render services to another and who knows or should know that the services will reduce the risk of physical harm to the other has a duty of reasonable care in conducting the undertaking if the failure to exercise such care increases the risk of harm, right? Or if the person to whom the services are rendered or another relies on the actors exercising reasonable care. 43 is duty to third parties based upon the undertaking, and 44 is duty to another based on taking charge of the other, right? What is 44? An actor who, despite no duty to do so, because that's what this category of duty undertakings is, an actor who, despite no duty to do so, takes charge of another who reasonably appears to be, one, imperiled, or two, helpless or unable to protect themselves. So be real careful if you don't have a duty of reasonable care because your conduct didn't create the risk, but you jump into the undertaking of the care of that person, because then you may find that you may be liable if you do not exercise reasonable care. Again, we're going to go through each of these in a lot more detail. This is simply Negligence 101. This is your overview. Okay. Why duty matters. Duty is the threshold. We start our duty analysis with, we start our negligence analysis with the element of duty. Why is duty such a big deal? It's simple. Before we turn to the Palsgraf case, let's address a core truth. Negligence liability must have limits. Negligence liability must have limits. If every careless act resulted in liability, then negligence liability would be limitless. It would be out of control. It would be unpredictable, and it would be socially and economically unworkable. There has to be some limitation on liability. So, if that is a core truth, where does the limitation come from? Where is the line that says this liability is going to be actionable, but this level of liability will not be actionable? Well, that's where duty comes in. That's where the duty element comes in. And Palsgraf is the case that shows that duty can be considered as either the gatekeeping function for limiting liability. Remember, as element one, if there is no duty, there is no liability. So that allows the shutdown of that litigation very early in the life of the litigation. So if we're looking for a way to limit negligence liability, let's put that threshold determination at the beginning, right? Thoughts? Ideas? Well, I know that you've read Palsgraf, and I know that you see that there is a dividing line in Palsgraf where Justice Cardozo, who actually writes the majority opinion, says, absolutely, we're going to use this element, the duty element. Let that element be determined by judges who have an interest in making sure that we have the ability to control our dockets. We're going to put the determination of that element in the hands of the courts, and we're going to make the decision, and we're going to make it quickly. And that's one way to keep our courts from being overrun with these cases, right? But you see that that's going to come toe to toe against what another one of Cardozo's colleagues thinks, and that's Justice Andrews, who says, absolutely agree. There must be some limitation on negligence liability, but it shouldn't be at the beginning of the case, and the decision shouldn't be made by judges. It should be later in the case during the causation phase, and that should be a question that is made by the jury. So here's the ultimate question. How far should one person be held responsible for the consequences of their carelessness? And when should that threshold decision be made? That pause is intentional. Hopefully, you're thinking about it, right? Let's jump into the evolution of duty. We've introduced the concept of negligence. We've given you the 4 elements. We've given you Restatement Third of Torts, Section 3, which is the definition of negligence. Restatement Third of Torts, Section 6, which is the definition of liability when we're talking about negligence. We've given you the 4 elements of negligence. We've given you duty as the first element being the threshold element, and we've given you the Restatement Third of Torts, Section 7, which is the explanation of what duty is. We've given you the Restatement Third of Torts, Section 37, which tells you that if you didn't create the risk, then you don't have a duty unless the court says otherwise, because the court is the one who's making the duty decision. And we've gone through the Restatement Third of Torts, Sections 38 through 44, that says, however, even if your conduct did not create the risk, you may still have a duty, because we do have some classes of cases that are legally recognized that establish a duty of care, even if your conduct didn't create the risk of harm, right? So all of that you've gotten in the last 40 minutes. Learn it, understand it, know it well. It is foundational. Now, we're going to take a little vacation here of sorts, because we're going to talk about the evolution of duty. We've already given you Restatement Third's understanding of duty. We've already given you the role of duty, and I've already previewed for you what the 2 justices in Palsgraf have said about where this duty decision should be made, if it should be made for the purposes of limiting liability. Yeah. Now that that's been done, let's take a moment or a few, and let's talk about the evolution of the duty element. Excellent. That takes us to Palsgraf, 1928. I've set it up for you, sort of, right? Palsgraf is the moment in American tort law where the battle lines are formally are formally drawn as to which element should serve as the limiting element for liability. Palsgraf is the moment in American tort law where the battle lines are formally drawn as to which element should serve as the limiting element for liability. I have Justice Cardozo, which is the writer of the majority opinion in Palsgraf, and I have Justice Andrews, who is the writer of the minority opinion. Now, understand this. Both of these justices agree that Ms. Palsgraf was badly injured. Both of these justices agree that the defendants, the two guards, these were the employees of the railroads, arguably were careless. Both justices agree. Ms. Palsgraf cannot recover. So what are we doing here? We're doing what lawyers do. We are discerning that even though they both agree on the outcome, they are strictly wedded to their positions, that the outcome should be determined in two different elements. Two different elements. And when you're speaking about the rule of law, where in the process the decisions are made is everything. Because just because, in this case, just because the justices agree on the outcome doesn't mean that the outcome necessarily had to be the same. So let's briefly talk about, well, what the heck is Palsgraf going on? Well, here's a summary, really briefly. Mrs. Palsgraf was at a train platform waiting for a train. At the other end of the platform was another train, a different train. The opposite end of Miss Palsgraf, there is a gentleman passenger who's trying to get on this other train that's going in the opposite direction of where Miss Palsgraf is trying to go. Okay. The gentleman passenger is trying to run and jump because the train has already started to leave the station. There are two guards, two railroad employees that are witnessing this gentleman passenger trying to get on the train. The one railroad employee that's still on the ground, I mean, the train's not moving very quickly, the train is just starting to leave the station. The one guard, train employee, who's on the ground helps kind of lift and catapult, right? Help kind of, run, jump, and I will push you up. While a second employee of the train is in the train car lifting, right? So one employee is going to push, the other one's going to pull, and we're going to get this gentleman passenger on the train. Gentleman passengers carrying a package, nondescript, not very big, but there's no markings of any concern. Believe it's wrapped in newspaper, no big deal. Well, this is when the big deal happens. As they are juggling the passenger to try to secure him on the plane, the package that the passenger is carrying is also juggling and eventually falls. And within the package are fireworks that explode. The fireworks explode, and in doing so, sends a shockwave down the platform at such a strength that it knocks over this huge set of scales that are used by the train station to weigh packages and luggage and things, right? The scale topples over onto Mrs. Palsgraf, and she's pretty severely injured. That's the story. Got it? Three-part issue statement. I've done it as an IRAC, which is an issue rule application conclusion, often yielding a question. And I framed the issue as a CRAC, where the difference is instead of the issue being framed as a question, it's framed as a declarative statement. It's framed as a conclusive statement. It's actually framed as a fact as opposed to a point of inquiry. Okay. IRAC, there's three pieces to this legal frame. It's really not just some hodgepodge of whatever it is you think is going to help you get started writing. It has three component parts. First part, an identification of the rule of law that's going to be applied in the reconciliation and the resolution of this problem. Second part, the actual legal question. And that's oftentimes the hardest part to do, but that's the part that's necessary, because if you can break all of this down to a question, then you know how to resolve it, right? And then the third part is a dispositive fact, a key fact, a fact that if this fact did not exist, we might have a case, but we wouldn't have this case, right? Three component parts. What's the rule of law? Negligence. That's what we're talking about. We're not talking about a battery. We're not talking about intentional infliction of emotional distress. We're not talking about strict liability. We're not talking about products liability. We're not talking about defamation. We are talking about the doctrine of negligence. That's the rule of law that is going to get applied in this hypothetical to resolve this legal question. Needs to be identified. Why do you identify it in the frame? So that the readers know that you know what you're talking about. And it helps you organize your legal argument. Great. What's the second thing? What's the legal question? What's the legal question? Is the question, did the defendant train employees hurt the gentleman passenger who's trying to get on the train? No. And now that could be a question if that gentleman filed a lawsuit against the railroad, and maybe they did, but that's not in our case. That's not the merit of our case. So what's the question? Is the question, was Miss Palsgraf negligent in standing where she stood? Maybe she shouldn't have stood so closely to the scales. Right. That could be a question if the defendants were to allege some defense like contributory negligence or something, right? That's a valid question. That's a valid line of inquiry, but that's not the question we're trying to resolve. What is the question we are trying to resolve? We are trying to resolve whether or not the two trained employees owed a duty of care to Miss Palsgraf. That's it, right? We're in element one where we're talking about duty. We're talking about this plaintiff. We're talking about these defendants in this case that are dealing with Miss Palsgraf's injuries. Why is it important for you to frame that as the author of the essay? Well, the reader, be it your supervising attorney, be it your judge, be it your professor, doesn't know that you know what the legal question is unless you tell them what the legal question is. So you got to give us the legal question. As a practitioner of 30 years, why is it important for me to frame my question so that I'm not wasting time answering all the other questions that might be interesting, but that are not necessary for this matter, right? It's all about isolating, framing, positioning, organizing. It is not busy work. And the way that you start your written response is the way that your written response is going to follow. If you start it sloppily all over the place, it's going to continue to be sloppy all over the place as you go through your analysis. What does that mean as a law student? That means your grades are going to suck. What does that mean as a lawyer? That means that your practice is going to suck, right? What's the third thing that has to be addressed in the framing of the issue in this IRAC? I need a fact. I need a fact that is the fact that, but for this fact, we wouldn't be here. What fact did I choose? Here's the fact. When the defendants assisted a passenger onto the train, that's a fact. The passenger had a concealed package that exploded, and that was the cause of the harm. Did those two defendants who assisted the passenger on the train with the package that exploded as a result of their assistance, did they owe Ms. Palsgraf a duty of care? Simple. That's it. Got it? How do I turn that into a conclusion? Because I have a professor who doesn't want an interrogatory at the beginning. They want a conclusive statement. Or I have a judge who wants a conclusive statement. How do I turn that? How do I do that? That seems so hard. That seems so difficult. Answer the question. In the IRAC version, you asked, did they have a duty? And the CRAC version, answer the question. Either they did owe a duty or they didn't owe a duty. But you still have to identify the rule of law, which is the doctrine of negligence, and you still have to identify the dispositive fact. You see the difference? So if you've got a professor who says, I want you to frame your issues as IRACs, frame them as IRACs, because there's something that it is that they're wanting you to master and practice. If you've got a professor who says, I want you to frame these as a CRAC, then frame it as a CRAC, because their request is legitimate. There's something that they're wanting you to master. Yield to that. Because if you've got a judge who says, I want an IRAC or a CRAC, you're going to yield to it. So I framed it for this frame for this reason, as I explained in class. All right, let's move beyond the framing. What are some of the dispositive issues? I gave you, and not some of the dispositive issues, what are some of the key facts? Some call them trigger facts. Some call them dispositive facts. What are some of the relevant facts? I've given you a list of them. Because we're not going to actually work the entirety of this case out for the negligence, I don't have a fact element map, right? But I did go ahead and list some of the key facts. Great. What's the procedural posture? This is what we're really trying to get to. The trial court, at trial, the case went to the jury as an ordinary negligence case. What do I mean by ordinary negligence? I mean that it was negligence, right? Duty, breach, causation, damages. It was negligence. Yeah. And so at trial, the case went to the jury as an ordinary negligence case. So the jury heard all of the facts, from duty to breach to causation to damages. The jury came back with a $6,000 verdict in favor of Mrs. Palsgraf. The judge accepted that that was the entry that was entered, and the railroad appealed. The Intermediate Appellate Court for New York affirmed the trial court's holding that Ms. Palsgraf was injured by the negligence of the railroad. Her $6,000 damage verdict was affirmed. The railroad appealed. Here's Cardozo. Cardozo, writing the opinion of the majority, reverses the ruling for Ms. Palsgraf and says that she could not recover. Cardozo establishes that Ms. Palsgraf could not recover because the railroad employees owed her no duty. According to Cardozo, a defendant's duty of care was only owed to plaintiffs who were foreseeable. In order for that plaintiff to be foreseeable, that plaintiff had to be within a designated zone of danger. That zone is relative to the conduct of the defendants. So, with the defendants and the gentleman passenger with the package that exploded, Cardozo said there would have been a relationship between the defendants and the passenger whose package exploded, right? Because I'm helping you, you've got a package, I destroy your package. That's so very relational. But Miss Palsgraf, who's down at the other end of the platform, unbeknownst to either the male passenger or the employees of the railroad, getting hit not by the train and not by the package and not by the passenger who they're trying to help, but getting hit as the result of a shock wave that knocks over a scale. Who could have prophesied that? How was any of that foreseeable? So, according to Cardozo, a duty of care is not owed to the world at large. There is no free willy-nilly duty of care. There is no duty of care in the air, right? Duty of care has to be positional. It has to be relational between the defendant's conduct and a plaintiff that could be anticipated to have suffered a harm by the conduct of the defendants. And because Ms. Palsgraf was so far away, because she's not a foreseeable plaintiff, she was not within a zone of anticipated danger, the railroad owed Ms. Palsgraf no duty. Because there was no duty, there can be no breach, etc., etc. There's no liability. In other words, Ms. Palsgraf was too far removed from the behavior of the railroad employees to be owed a duty of care. Done. That's Cardozo. So we're going to limit liability. Where we're going to limit it, we're going to limit it at element 1, which is duty. We're going to let the judge make a decision if there is or is not a duty. If the judge makes the decision that there's not a duty, basing that on the foreseeability of the plaintiff and the zone of danger, then the case is over. Get it? That's me wiping my hands. Cardozo, it's done. Let's look at Andrews. Andrews says, duty is owed to society at large. There is no consideration for this fictitious, foreseeable plaintiff. Everybody's a plaintiff. If you are conducting yourself in the world, then everybody in the world is a plaintiff. Now, let's be reasonable. You may be able to establish that the plaintiff is too far removed and the duty of care should not be extended that thinly. But according to Andrews, that's a proximate cause question. That's not a duty question. That's a proximate cause question. And because it's a proximate cause question, the limitation of negligence liability is a fact question. And if it's a fact question, what does that mean? That means it's a jury question, not a judge question. And so Andrews supports the idea of foreseeability, not foreseeability of this fictive foreseeable plaintiff in this fictive zone of danger, right? But the foreseeability that Andrews support is the type of harm that's suffered, the type of harm that can be expected to arise from the conduct of the defendants. Oh. And here is where it works. Who gets to make the call? The jury does. Right? So, in Andrews' use of limiting liability for negligence, Andrew says all of this stuff has got to come back to the jury. You can't dismiss the case outright. All of this stuff gets to come back to the jury, right? We have a constitutional right to be heard. That here's your jury, here's your procedural due process. You have a right to bring this suit, and you have a right to a jury of your peers, and they get to make all of these decisions. Judges shouldn't get in the way and helicopter or hijack the process. So instead of kicking the case out because there's no duty, like Cardozo did when the majority reversed the trial court and the intermediate court, instead of kicking Ms. Palsgraf's case out at the beginning, the case comes in, the witnesses get to testify, the evidence gets to come in, and then the jury gets to determine the weight of the evidence and the credibility of the witnesses. And in their inquiry, when they get to proximate cause and what needs to be covered under the analysis of proximate cause, there would be conversation by the jury as to whether or not Miss Palsgraf was too remote in her position. The jury would get to make a decision as to the connection between the defendant's actions and Miss Palsgraf's injuries. The jury would get to make a decision about what's fair and how the facts have been played out, not the judge, right? So for Andrews, there is no consideration of a fictive plaintiff. There is no consideration for this fictive zone of danger. Duty is not relational, it's universal. If you are conducting yourself in the world, then you owe the world a duty of care. And whether or not your breach of that duty makes you liable is a proximate cause determination. Get it? That's the difference. So they're both saying that there needs to be some liability limitation. They're both saying that that limitation is going to be exercised through an element of negligence. Cardozo is saying the element that's going to make that limitation decision is the first element, which is duty, and that decision should be decided by the judge. Andrews is saying that limiting element needs to be proximate cause, and that needs to happen by the jury. That's the difference. Got it? So, with that being said, Palsgraf is not a dispute about facts. It's a dispute about where foreseeability belongs in the negligence analysis. Now, in the next lecture, we'll turn to the solution of the Palsgraf problem. Because what happened? Well, we've got a majority opinion. That's the opinion that's written by Cardozo. And that is the opinion that had led the analysis of negligence for the next 80 to 100 years, right? So we had a decision, but what you could see in practice was that the idea of foreseeability started to gradually move organically from the idea of this foreseeable plaintiff, and the concept of proximate cause began to grow stronger and stronger and stronger and stronger in application. And so we eventually get to the third restatement of torts, where we get some clarity as into the rule of law. And we will discuss that clarity through third restatement of torts 3, 6, 7, 37, and 38 through 44 in our second lecture. That's where modern negligence and the doctrine of modern negligence begins. Excellent. That's it for video 1. Rest, I'll post video 2 that will walk us through the doctrine of modern negligence as we go through the assigned cases. Thank you again for paying attention.